Hello, everyone, and welcome. Thank you so much for joining us. In case you don't know by now, my name is Bree Van Til. I'm the Director of Education at Alt Legal, and I'm also the Master of Ceremonies for Alt Legal Connect. Thank you so much for joining us. We're about to start with getting into the weeds, cannabis law and IP protection. But before we do, let me start by talking about our code of conduct, which is to say, don't be a jerk. And if someone else at this conference is being a jerk to you, please just let us know. We have no patience for that. Okay, in terms of CLE, if you are watching this session live, you may qualify for CLE credit. Please do keep in mind that we're required to keep detailed attendance records, and those will include whether you were in the session and whether it was the top tab. Please don't multitask during this. And we also need you to take note of the code that we will say at a random time during the session. Make note of that. I'll say it twice. Write it down, and you'll input that code into the survey that we send you at the end. So to qualify for CLE credit, you need to be in the session for the entire time, and you need to have the code. If for some reason you miss the survey link, I'll send you that at the end of the evening in our recap. And finally, CLE is only offered for the live presentation. So if you're watching this in a recording, I apologize, but you do not qualify for CLE credit. If you have any questions, feel free to use the chat, either in Brella or in Big Marker, whichever platform you happen to be in. You are welcome to put your questions there, and we will make sure that Amanda and Shabnam get them. It might help if you use the @presenter tag, just so we can find them, but we'll get them over. This session has been brought to you by Alt Legal. Now I want to introduce our speakers. Well, some people sponsored other sessions. This was ours though, man. Okay, we get all the pot. All right. Shabnam is a partner at Brandon Branch LLP and founding president of the International Cannabis Bar Association. Her background is in trademark law, and she cut her teeth on all things intellectual property as an associate at O'Melveny and Myers in San Francisco. Since her days in big law, Shabnam has expanded her practice to include promotions and sweepstakes law, advertising law, and the representation of lawful cannabis and hemp companies throughout the United States. She was named a California Rising Star 3 years ago, and she's a super lawyer. That's pretty exciting stuff.
Is it still rising, or?
She's just a star at her peak in the sky. She's just going to stay there. Okay. Amanda is a founding partner of Brandon Branch LLP and the co-founder of the National Cannabis Bar Association. Strangely, same thing. She helps creative entrepreneurs across the variety of industries protect, leverage, and enforce their intellectual property. She specializes in helping clients navigate highly regulated industries such as cannabis, hemp, dietary supplements, and new and emerging technologies. She also advises on advertising, marketing, website, and labeling compliance. She's also a Northern California Rising Star by Super Lawyers Magazine for the past 2 years. Thank you so much, and welcome to Amanda and Shabnam. We're glad to have you here.
Hi. Thank you. We're glad to be here.
We're really glad to be here. We would have been gladder to have been in Brooklyn, but we're glad.
It's true.
Yeah.
We're glad to be here anyway.
Yeah. I was slides to go back to the very beginning. There you go. Thank you. I'll let you control them, or?
Yeah, I'll control them. I will control them. Hello, everyone. Thank you so much for attending. We would usually make a joke about how we're not providing marijuana, but that's probably obvious since this is remote. But otherwise, we totally would be. No, I'm just kidding. Or am I? So, as Bree alluded to, we focus the bulk of our practice on cannabis and hemp. and companies that operate in those spaces. And we, in particular, advise on intellectual property and advertising and other issues like that. But we're going to focus on trademarks today, since this panel is brought to you by Alt Legal. And so we're going to talk about, yes, getting into the weeds, cannabis law and IP protection. Shabnam, you want to go over sort of an overview of how we're going to get into that?
Yes, what we'll cover. I'm going to read this slide. We are going to start with terms to know, a little bit of a dictionary. Things you're going to want to know, or words you're going to want to be familiar with as you embark on serving the industry, or maybe you already do serve the industry, which is terrific, then this stuff's going to be familiar to you. And then we're going to get into the details of how the U.S. Patent and Trademark Office treats cannabis-related trademark applications, whether that cannabis is hemp or is marijuana. And then we're going to talk in some detail about how to, or sort of best practices in clearing and protecting the cannabis-related brands. And we'll also touch on some recent case law as well. And the recent case law will cover stuff from both the TTAB and what's happening in the district courts.
All right, excellent. So let's talk about the status of legalization generally right now. As you are probably aware, there's been a real move on a state-by-state level to legalize cannabis in various forms. We'll get into definitions in a little bit. But we now have 11 what we're calling fully legal states, which essentially means states that allow even adult use of marijuana, not just medical. And so we have 11 fully legal states plus DC. That one's a little wonky, but there you have it. And you can see that there is change coming, and it is coming in different paces across the different states, and maybe we'll eventually see federal legalization. But until then, protecting intellectual property in cannabis obviously presents some unique issues, since intellectual property tends to be federal, and cannabis remains federally unlawful, with some exceptions, as we'll talk about. So you probably also have a sense that the market of cannabis products is pretty sizable. According to New Frontier data, the size of the used market is expected to reach 24.3 billion by the end of 2021. So if you're not already in this market, it's time to jump on. And I believe that doesn't even take into account the lawful hemp market, which is separate and also really promising. And so what are these distinctions that I keep making? Let's get into it. So the word cannabis is actually a botanical term that has no legal significance. It refers to a genus of the flowering plant, and there are some number of species within this genus. But the terms that I'm distinguishing between that are important to know are hemp and marijuana. And so marijuana refers to what we think of as weed, the cannabis that gets you high. Cannabis containing more than 0.3% Delta-9 THC on a dry weight basis. Hemp is cannabis that contains no more than, so less than or equal to 0.3% Delta-9 THC on a dry weight basis. So when we say cannabis, people often take that to mean marijuana, thinking that that refers to marijuana, because we have sort of adopted the term cannabis as a nicer way to say marijuana, let's say, for a while. But then that got tricky, because with the passage of the Farm Bill in 2018, the federal government finally got on board with these two distinct terms, marijuana and hemp. So now, going forward, we'll try in this presentation to refer to marijuana as cannabis that is regulated, as we saw on this chart. So this refers to the status of marijuana legalization. Whereas by hemp, we are referring to this cannabis sativa with less than 0.3% THC, and it is no longer scheduled. So we'll talk a little bit about what that means, the implications of that later in the presentation, but hemp as a product is no longer included on the Controlled Substances Act the way marijuana is. So those are the important distinctions to get here. And then, whoops, there we go. A couple more terms to know as we go through this. So a cannabinoid is they are chemicals that influence cell receptors in the brain and body and change how those behave. So there are different cannabinoids. THC tetrahydrocannabinol is, I'm jumping down to the third definition here, is the common cannabinoid and the one that the amount determines whether it's hemp or marijuana. And that's the one we think of that gets us high. Another popular cannabinoid is CBD, cannabidiol, or cannabidiol, and it's probably the second most commonly found. It is popular for therapeutic effects. It tends not to have the same sort of psychoactive stoned feeling that is often used in children with epilepsy and other conditions like that. So then just a couple of other things that Shabnam's going to talk about specific products on the upcoming slides. But concentrate or extract is any material that's created by refining or processing the cannabis flowers. And that tends to have a much higher potency because the potency has been concentrated. So various things are made with cannabis extract. Another thing to know, often overlooked, are terpenes. So terpenes are organic compounds that appear in all manner of plants, and they produce aroma and flavor, but they're particularly important in cannabis. They may affect the experience that you have when consuming a cannabis product. Some companies have really worked to develop products that have a real special combination of cannabinoids and terpenes to give, the ideal effect. We're still studying all of this, but you will see terpenes come up a lot when you're talking about cannabis. And I've already done what I said I wouldn't do, which is refer to cannabis when I think mean marijuana in this case, although terpenes are present in both marijuana and hemp. So Shabnam, those are the boring definitions. What are we actually talking about?
These are the exciting products. So the cannabis industry has a whole bunch of really exciting stuff going on. It's not just a dime bag of weed anymore, although it is still a dime bag of weed. And there's an example of it right up there, probably more than $10 worth. And that's referred to now as flower. On the slide earlier, I don't know if the size of the market slide showed it, but flower tends to still be the highest selling part of the market. That doesn't necessarily mean most of your clients are going to have a brand associated with flower. Actually, I'd say most of our clients are probably manufactured products clients, but we also represent a lot of cultivators and a lot of folks who bring actual flower to the market in, branded flower. Next to that, it looks like we have an infused topical. Topicals are huge. They're everywhere, but they actually represent a pretty small share of the market at this time. And topicals are really interesting because they present a real opportunity for brand ownership and brand protection. And they sort of cross over both between the world of marijuana infused and hemp derived oils and extracts, or CBD infused. So it's like this kind of mushy thing in the middle that, because of the way trademark protection works at the US Patent and Trademark Office, you can actually get a lot of protection there if your client is providing an infused topical. In the sort of long pen next to it, if anybody here vapes tobacco, you'll recognize that. It's just a vape pen and it's got cannabis oil in it. I hear that some people vape hemp oil, but that's probably marijuana oil in that. That's a big part of the market. And actually, when Amanda and I first started Brand and Branch, I'd say like every 2 out of every 3 calls, the product manufacturers made vape products. And now it isn't the case anymore, is it? Like, I don't even remember the last time someone called us up. Yeah, the market.
Well,
is really
I'm sure VapeGate last year had something to do with that, and some of the view around e-cig.
Yeah, absolutely. And so it's just sort of shifting, and the product on the right is, or on the to the right of the vape pen, is maybe capsules and pills of that nature. That's actually sort of for the marijuana world, like newer and upcoming form of consumption. And it's kind of interesting. It's like sort of the analog of like actual medication, but in the marijuana form. And then below that, other than the concentrate, the wax on the far right, which you heat up and then inhale the vapors from it, the other 2 things, or sort of group of things, are infused edibles and infused beverages. And that is what we would refer to as a manufactured product. It's growing in market share, but it represents a lot of our clients and our billable work at our firm, and it may do the same for you. It's just a big deal, infused food products. And, as you go state to state, it really differs whether people are looking for health foods, whether people are looking for sweet foods and things of that nature. And often regulations will speak directly to this product group. What it may include, what shapes it may take, things of that nature. And it also provides a big part of our work in terms of labeling and packaging reviews. So the type of packaging is regulated at a state-by-state level, and then the language on the label is too. That's a big part of what we do that Amanda actually focuses on. So we won't get into that labeling review in this presentation, but it's something that's interesting for cannabis lawyers. Next, or trademark attorneys that serve the cannabis industry, I should say. So then there's also all this other stuff, right? There's online search services. There's point of sale services. There are Viridian is an employment service. There's also another one called Vanks, which is huge right now. The Hybrid Creative is a creative agency that's focused on the cannabis industry. Leafly is a huge online company that is basically a repository of information, a strain database, product reviews. I think now they even operate a product finder, the whole bit. And actually, while I'm on it, product finders and maps are big. Just about everybody represents at least one of these companies. And in the state of California, we have one really huge one that's basically like the laws are being set in accordance with what this company does and doesn't do. So it's a big deal, and that's an area where you can get a lot of trademark protection because much of what your client will be doing online will be federally lawful. And then we'll get to this both in the registration and in the product searching or the trademark searching part of the presentation, but just wanted to give you a sense of how creative really and pretty some of the branding is in this industry. It's distinctive, it's unique, and it's litigated. And so actually at least one of these you'll see we'll talk about in the disputes part of the presentation later, but most of these are California brands. A couple of them are outside of California. And you'll see right in the middle, Leaf Spice Snoop. Of course, the famous brand and the celebrity brands are huge. Actually, Bob Marley, Grateful Dead is releasing, Jerry Garcia is releasing one. And then what was the other one that was just released? Santana, Carlos Santana just released his brand of cannabis too. So it's all over the place. If you know anybody famous who ever smoked pot at all, then call them up and start doing a celebrity brand. Anyway, we'll talk a little bit more about brands as we move forward. But so quickly, just to give people a sense, trademark attorneys, we're business attorneys. People are often talking to us about what's going on. What are people developing in terms of assets in the cannabis industry? So brands are actually a big deal. And people really build companies. They sell companies just based off of brand identity alone. So that's really the trademark portfolios. Along with that is the patent portfolio. And as you may know, you can secure a patent registration in the United States for even things that are unlawful, including cannabis, like formulations, uses, machines, things of that nature. So that ends up being a big part of the portfolio. We actually have worked on some patent licenses in this industry, and it's a big deal to monetize that. Trade secrets are a big asset. Often there's a recipe or a formula or just some know-how. Occasionally standard operating procedures can be trade secrets. And then, honestly, there's just a lot of agreements. Because your clients are necessarily going to be operating state to state, they're not going to have, one or two big national supply chain agreements. They're going to have many, many separate supply chain agreements in every state that they're operating in. Each one of those agreements is going to be part of their asset portfolio. It's high value. Leases, same thing. Most cannabis companies, at least in California, don't own the property that they operate on. They're leasing it, at least for manufacturing facilities. And of course, equipment. Some of the manufacturing process, pill pressers, packaging equipment, bottling equipment, things of that nature end up being part of the asset portfolio. So especially for IP attorneys, when you're doing diligence, you really might be looking at all this, but for sure you'll be doing diligence on those IP portfolios. Moving on. Do you want me to cover challenges too? So those were some of the upsides or opportunities, and then some of the challenges for cannabis companies. I forget, what are those called? There hasn't been an upside in so long. So some of the challenges, you notice how the list is super long. Some of the challenges in the cannabis industry. Well, we'll talk about this later, but clearance searching obviously is a big challenge. Actually, clearance searching isn't a challenge in a negative way. I think it's sort of an opportunity challenge. It makes lawyering really fun because it's sort of a whole new way. It's an exciting way to approach searches. One of the challenges that's truly a challenge is it's difficult to distinguish brands. It's a lot of people are coming up with the same idea for those trademarks, including translations of the same words and ideas. And it's a lot of coaching people to really move in the direction of distinct and unique. Enforcement is just an outright train wreck. We will talk about that later. It's ugly, it's difficult, it's complicated, uncertain to say the least. And this issue of coexistence, which actually sort of ties in with enforcement, it's complicated. It's a complicated world because of the federal law issue and then the state-to-state concept. We're in this right now, several clients, both on the defense end and the enforcement end, having to do with this issue of federal illegality with a state-to-state system. And then, of course, differing regulatory schemes. It really does affect what your client might have from state to state. When I was talking about packaging and labeling, when we're reviewing a label, it's absolutely going to look different from state to state. And so oftentimes, well, for hemp clients, even hemp clients, the regulations exist now at different state levels, and you have to provide different advice. But for marijuana clients, for sure, there's going to be a different regulatory scheme, and they must abide by it. It's not like you can say, oh, just go for the strictest state like you would with privacy or with hemp. With cannabis, with marijuana, they really actually need to comply with every single part of every single state's regulation. So it might change quite a bit about their product, could change product shape, could change the product name, definitely will change the product labeling. Probably not the product dosage at this point. Most of that's pretty standard state to state, but those are some of the challenges.
Yes, I have never felt so in favor of FDA preemption around labeling and packaging as now that we are in the cannabis and hemp, marijuana and hemp spaces. It would be really nice to have guidance from just one agency. So yeah, so those are some of the challenges and opportunities. But let's talk about trademark registration. One of the biggest myths and sort of common misconceptions that we hear is that cannabis companies cannot get a federal trademark registration. That is not true. There is some nuance to it. If that were true, I'm not sure what our firm would have been doing for the last 5 years. So it must be somewhat possible for cannabis clients to obtain IP protection. So what does that look like? You're all trademark attorneys, presumably. So I don't have to start from the basics with you. I think you'll understand when I say the trademark office cares what's listed in the description of goods or services. That is what they care about. So if your description of goods or services could encompass something that's federally unlawful, that's a problem. If it obviously encompasses something federally unlawful, that's a problem. But if it doesn't, and that it gets a little wonky around paraphernalia, but if it doesn't, if we're protecting something that is itself truly federally lawful, then the trademark office shouldn't care if your client also does things that violate federal law, as long as those things could not be included in the description of goods and services. So basically, what does that mean in practice? That means we're not filing for things like infused edibles, delivering marijuana, growing cannabis flower, not at the federal level. Those will be refused. We're going to get into the nuance of that a bit more, but basically they're refused because there is no use in commerce. Because the trademark office, the federal courts say, in order for use in commerce to be the valid kind that the Lanham Act recognizes, it needs to be federally lawful use. And you can't engage in federally lawful use of cannabis goods and services. Therefore, you are not, you're not using this mark in commerce for the purposes of getting a federal trademark registration. So fine, but cannabis companies do other things too. And that's really the focus. We hear a lot of people say, okay, then I'll just get a registration for a t-shirt. And again, I appreciate that you're all trademark attorneys, and so you can see some of the limitations of that approach. If you have a cannabis client and they want to get registration for their brand with a t-shirt because t-shirts and clothing, just to promote their merchandise, their brand is a big thing they do, you're certainly, in theory, able to get that. The same obvious issues arise that would arise in any industry. If it's just on the front of the t-shirt, you're probably going to get a refusal because it's merely ornamental. A lot of companies apply for clothing related marks. So you're going to run into companies that aren't in fact related, but that you have a conflict with at the trademark office. So for example, we had a vape pen client years ago who ended up in a big fight with a university out east. Not because they had anything in common other than that both were selling t-shirts, but it was the t-shirts that triggered the fight. So I tend to feel that the clothing approach is not as helpful as some of the other ancillary goods and services that you can protect. So things that we tend to focus on are online services in particular. So we spend a lot of time encouraging our clients to have blogs, to have a robust website that provides a lot of information. Often they don't want to, they just want to sell weed. They have enough to worry about with that. But the trademark strategy really does kind of require them to do other things. So we encourage them to provide information, to sell other, ancillary goods that are federally lawful. Again, that can get a little tricky because paraphernalia, the advertising is what determines whether something is considered federally unlawful paraphernalia. But there are some options. Now, one thing to keep in mind is if a cannabis client files an application for goods or services that are related to cannabis, let's say providing information about cannabis products and the cannabis industry, they are likely to get at least an initial refusal inquiring whether the use violates the Controlled Substances Act. And if that application is drafted well, if that application is focused on providing information, then it's an easy answer. As the attorney handling it, your response is, no, absolutely. Providing information like this does not violate federal law. And I am only seeking protection in connection with services that are in compliance with federal law. A lot of time clients file these things on their own. They get that initial refusal and they think, oh, that's it. I can't move forward. And depending how the application is drafted, that may be true. We've seen clients come to us having filed applications for, delivering marijuana. You're not going to save that application. But if it's drafted broadly enough, we'll talk about this. There can be ways to modify the application if needed, or it may just be as simple as answering the examiner's question by saying, no, in fact, these services, these goods that I'm trying to protect do not violate the Controlled Substances Act or whatever law is being cited. Interestingly, in the beginning, when we first started doing this about 6 years ago, the trademark office would often ask, does applicant violate the Controlled Substances Act? Or do applicants' activities, do their business activities violate federal law? In this very sort of broad, inquiry that was not focused on do the services in the application violate federal law? And so we made a point of responding and answering the question that we wanted them to ask. And we weren't alone in this, but a lot of the attorneys working at that time did. We started saying, well, the services in the application do not, et cetera. And they started asking the right question after a little while. Now they ask far too many questions, but they are more specific. So I guess in that sense, we could consider that to potentially be a win. Something else to note. So I've been focused on federally lawful goods and services. And so I've been talking about mostly marijuana clients and how to get trademark registrations for them. For hemp clients, and in some cases, this might be the same company operating in both spaces, although that's a little more complicated. But for your hemp clients, there are some paths to federal protection with a big asterisk. And so what I mean about that is in December 2018, the Farm Bill was passed. We talked about this a little bit before that made this distinction between hemp and marijuana and legalized hemp, cannabis containing less than 0.3% THC. And the Trademark Office was aware of this and knew that they had a lot of applications already pending that covered goods that would now be legal, potentially, under the Farm Bill. They also knew that there was a huge influx filed after the Farm Bill passed because everyone said, oh, look, this is legal. I can get my trademark registered now. And so the Trademark Office did something that certainly to us seems incredibly unprecedented. But hey, it's 2020. No, I'm kidding. This was 2019. So this was even weird for that year. They issued this examination guide that explained how they would examine marks for, they say, cannabis and cannabis related goods and services. It's focused on hemp products that comply with the Farm Bill. A lot of it makes sense. A lot of it goes through, we're going to make sure that these products do comply with the Farm Bill, that the THC content is less than 0.3%, et cetera, et cetera. They look to the FDA, which gave guidance saying, essentially, we have not approved CBD to be added to food or dietary supplements. but we don't really have a position on cosmetics. And then we know that they also don't have a position on vapable or smokable products. So one thing this exam guide says is we're not going to give registrations for ingestible CBD products or hemp products like that, except for certain hemp products that are generally recognized as safe. But we will give registrations for things that are not ingestible. So we've seen that they'll give them for topicals and smokable products. The weird thing that it did, though, is it said, but everyone is going to have to change their filing date to the date the Farm Bill passed. So whether you filed your application 3 years ago and maybe it was still pending because it was suspended or something, or you filed it on December 20th, 2018, you're going to have December 20th, 2018 as your filing date. It seems that the office did this because they wanted the applicants to have had a bona fide intent to lawfully use the mark in commerce at the time it was filed. So since they can't change the intent, they've just changed the filing date. But it creates a weird situation, and it certainly is ripe to create real problems to fight over priority. If a company filed 3 years prior, but then had to change their filing date to December 20th, 2018, and then they're fighting with someone who filed on that day, we've seen a little bit of guidance from the trademark office about how that might shake out, but I don't think we have any certainty of how that fight would play out. So it's really strange. We do think it could suggest what may happen with marijuana. One day, presumably, marijuana will become legal on the federal level somehow through rescheduling, descheduling, a separate bill, who knows. But presumably at some point that will change, and we will face a similar question at the trademark office. What happens to applications that were pending? They were filed before the law changed. So could applicant have a bona fide intent to use the mark lawfully if the law was what it was before it changed? It's going to raise all of these same issues again. And who knows? One thing I'll say is if we're reading the tea leaves on this and they just let us change the filing date, I mean, generally, we don't encourage clients to file applications for federally unlawful goods or services just in some kind of waiting game for the law to change, because if you don't have that bona fide intent to use, you're not going to be able to go back and claim it. But I don't know if they're going to follow a similar path with the marijuana examination guide, there would be some benefit to having those applications on file if you can amend the filing date. So it's really hard to predict. All we can really say is this was an unexpected result, but at least we have been able to get some CBD related registrations or hemp CBD related registrations for our clients. All right. Do you want me to talk about this, or would you like to go through these, Shabnam? I can't remember where we.
You go ahead. You're doing.
I'll go ahead. Okay.
If you want.
All right. So basically, as I said before, you can't register anything if the goods or services violate federal law. And the theory, we disagree, but the theory is, in order to have use in commerce recognized for the purposes of trademark registration, it must be federally lawful use. So in 2016, we got to see this theory tested at the TTAB. We've yet to see it tested beyond the TTAB, which would be the really exciting thing. But an applicant out of Washington filed an application for the mark Herbal Access, and they listed like the sale of various herbs, but they included in their application, actually I think I have this more in detail in the next slide. Oops. They included in their application a picture of their dispensary and said, get your marijuana here. So there was no subtle sort of like, I wonder if this is cannabis. It was clearly cannabis, and the description of services was broad enough to encompass the sale of marijuana. So this is a situation where the applicant filed pro se, and perhaps if they had worked with an attorney from the outset, they would have had a better record on which to challenge this. But as it happened, they were not able to get anywhere. They challenged the examining attorney's refusal based on lawful use, and the TTAB said, look, we're not going to go looking for unlawful use, but when it's either indicated by the application or it just involves a per se violation of federal law, we can't look the other way. We're going to refuse it. in most cases, what this has meant for us is that we have to carve out federally unlawful things from the goods and services so that the description can't encompass that. It ends up being a little wacky in practice because we'll have things like, let's say we have a client who is selling cannabis but also basil. So they may file an application for cultivating basil or selling basil, or I'm sorry, cultivating herbs or selling herbs. But the trademark office may then respond and say, hey, wait a minute, I think you mean cannabis. And we'll say, oh, I'm sorry, selling herbs other than cannabis. Understandably, our clients are like, why would I want my registration to carve out the main thing I'm doing? And we agree, but in fact, that's all we can do. And so, we are left with hoping to make creative arguments like, well, basil's really similar to other herbs. And sure, we explicitly carved out marijuana, but not because we're not doing it, just because it's unlawful and we had to in order to get the registration. But, people will confuse all of these herbs. It's a little bit of it's a little bit of a creative argument, as Shabnam will talk about later. But the thing to keep in mind is that having these applications on file puts other people on notice that your client is claiming rights in the mark. So even if you don't get the scope of registration you would hope with a non-cannabis client, it can still be really valuable. After the In re Brown decision, we saw a couple similar decisions at the TTAB. This Juju Joints case, also in 2016, it was refused. And in that case, the description of goods actually said the vaporizers were for use with cannabis. So again, as with all trademark applications, the filing strategy at the outset is really crucial. And we're seeing some bad law created when that's done without good guidance. And then just moving on to the three more recent cases, In re Ultra Trimmer, also in 2016, was a banner year for marijuana issues at the TTAB. There, it was more of the paraphernalia issue we were talking about before. So registration was refused not because the goods listed in the application showed a per se violation, but because if you looked at the applicant's website, it was clear that the machine that they were trying to protect was used for trimming marijuana. And in fact, the applicant didn't contest that in the record. They tried to make some policy arguments about lawful use and why the TTAB should recognize this, and that was all rejected. The TTAB is obviously not the place to be making novel policy arguments. They are not excited about that. Then Canopy Growth, that was actually Asinor from Asinine from Ultra Trim or from Juju Joints, the previous one. So very similar case law saying, you can't have bona fide intent to use the mark if the goods are unlawful. And then finally, we saw in a recent case, Stanley Brothers Social Enterprises, that's Charlotte's Web hemp company. We saw the unlawful use doctrine that usually relied on marijuana being unlawful under the Controlled Substances Act. We saw that extended to CBD infused goods that are prohibited by the Food, Drug, and Cosmetic Act. And that's the thing I was just talking about, where the FDA said you cannot sell ingestible CBD products. And so the TTAB, following its exam, the trademark office following its exam guide, refused registration of ingestible CBD goods, and the TTAB affirmed. So that's where it stands now.
Where it's at.
Where it's at. Sorry.
We get that. Oh, that's okay. Question all the time. Wait, in foods containing CBD are unlawful, but I see them everywhere. And yes, some states have decided to go to make them lawful. In Colorado, hemp-derived CBD-infused food is lawful under state law, but most states just comply with whatever the federal government's doing, like here in California. So, and actually, just to add on to that, there's another recent case that came out right after that Charlotte's Web case that makes clear that even if your product is lawful under state law for hemp, it's the same thing as a CBD infused food. It's still unlawful under federal law. So no registration for you. Okay, so what do we do when we're helping clients select marks? Clearance searching. Did that also say enforcement? Clearance searching, registration, and clearance. Okay, great. So we covered registration. Let's cover clearance. It's really exciting, actually. Like I said earlier, trademark clearance in the cannabis industry. It actually requires a lot of creativity and a lot of looking around. So what we always say, and let me just see what the next slide is. Oh, got it. Okay, that's great. So this is sort of a high level. So one, obviously be creative. And that means really think about what might be either a mainstream analog to your client's product or what might just be a natural outgrowth of what your client does in your client's product. And look vertically within the cannabis industry and across industries. So one thing that's a little bit unique about the cannabis industry is in every state where marijuana is legal, the marijuana products may only be purchased in certain kinds of dispensaries, retail stores, or medical marijuana dispensaries, and they're all regulated. And usually other goods can't be sold there, and always those goods can't be sold at other stores. So you might find a hemp product at Walgreens, but you're certainly not going to find a marijuana product at Walgreens. And then whether or not other stuff can be sold at a dispensary is super state by state regulated. But I don't know of any state where marijuana can just wholesale be sold at a non-regulated cannabis dispensary. So because of that, what happens? An entire world of products is sold under one roof and often displayed within just a handful of shelves. There are some states that have really big dispensaries. In Las Vegas, there's some really big dispensaries. Here in California, we have a few that have just a bigger footprint. But a lot of places, the dispensaries are actually pretty small. So you'll have all of 30 shelves, a handful of display cases. In fact, the display mechanism differs from state to state, depending on the regulations. So as a result, you'll walk up to a counter and you'll have a food product and a topical product and some joints and some pills and some lighters and just a whole bunch of stuff within, 8 inches of each other in close proximity. So you really have to be thinking about that, where ordinarily you might make arguments like, hey, examining attorney, the cited product is only available in the back of the grocery store and my guy's stuff is available only in the health food aisle, or, this apparel and that food product aren't even sold in the same store. Well, in the world of cannabis, it's all in the same place. Whatever it is, it's all in the same place. And so that makes the likelihood of confusion analysis a little bit different because you absolutely have the same trade channel. And the examining attorneys know this, by the way. And so they'll pick up on that. So you really need to be thinking about who else's product, your client's product, is going to come near. And this also extends for services as well. So a cultivator in one state, though that brand flower or even those cultivation services may not necessarily appear in another state, the fact is within the regulated industry, people come to know certain brands and identities even from state to state. So you wouldn't ordinarily, you might have someone who's selling shoes or a food product here in California, you might not think so much about a one-off, farmer in another state. But in the cannabis industry, you really have to be thinking about who's doing what and where and what those supply chains look like. This also goes for everyone in the supply chain, including where the financing is coming from, whether there might be a investment firm or a venture capital firm with that same name, like the whole bit. Everybody's looking at everything. So you really have to be thinking about that vertically and across industries. So the other part of that is look at the mainstream analog version of what your client is doing. We're here to tell you that absolutely the mainstream food and beverage industries are watching the cannabis industry. In fact, there's now, I think, sort of a come to be well-known kind of enforcement strategy by the edible arrangements folks going after various cannabis companies with some part of one of those words in their names. So you really have to be thinking about what's going on in the mainstream industry. Is there a granola bar with that same name? And we'll talk about a little bit later. The Kiva case is a mainstream brand of natural foods that got into a dispute with the marijuana-infused brand of food company based here out of California, but has now expanded into other states. So definitely be looking at those. And when you're looking at other industries, I would also look at certain companies that just might have some reputational concerns or something where maybe they wouldn't feel comfortable with a cannabis company having the same name. In those situations, the case is harder for them to make. If there isn't a regular likelihood of confusion, you'll want to go through a quick dilution analysis. But if the brand, the mainstream brand, truly is famous and could prove fame, advise your client away from that brand. So no Nike weed, for example. Or maybe Nike itself wants to make weed. So anyway, also look for generic and descriptive strain names. We'll talk quickly about strains later, But the examining attorneys at the U.S. Patent and Trademark Office know what strains are. And in case you don't know what strains are, they're basically varietals of different types of marijuana and hemp strains too. And that website we talked about for a second earlier, Leafly, it's a huge database of marijuana strain names. And so if your client chooses a strain name, or even like this bullet says jargon for weed, then the examining attorneys may give you a descriptive refusal depending on what your goods and services are. Other tips is search everywhere. Instagram, Leafly, the examining attorneys are searching everywhere. You should search everywhere too, and really be drawing things out for your clients, including different meanings of words that they use. There was a company here in California that picked this word as their trademark, and it turns out that word had a really negative historical connotation among longtime cannabis cultivators in California, and boy, did they get dragged around for using that. It was like the indicator that they were newcomers and didn't know what they were doing, and they picked, a word with much negative connotation for their product. So, think about things like that, the historical impact, the racial impact, and things of that nature. It's a really big deal in the cannabis industry. So moving on to descriptiveness and frequently used words. No surprise there. The word farm, the word cannabis, green, wellness. This is just a great old slide. Things have probably changed a little bit. This is an older slide, but you still see a lot of this. And then your client's you're going to show them the slide and they're going to be like, oh, okay, no problem. They're going to come back with PHARM. You're going to know. They're going to translate green into a whole bunch of different languages. You're going to recognize all of them, and so is the examining attorney. And so there's just a lot of this, a lot of like thinking that they're being distinct and creative, but really it's, something canna. We probably see that a little bit less now, but there used to be a time when I would just practically be yelling at sessions talking about how we want to discourage people from using the word canna in their brand. So this is sort of the words to avoid or words to look for, words you're for sure going to have to disclaim if they're included in the trademark at registration. And then here we have, which green room. This is another big problem. This is actually probably something that we see as a historical, leftover sort of branding strategy, in particular among dispensaries. I think maybe we are seeing a lot more distinctive and creative names. I think the best problem, or the problem that this slide illustrates the best, is that all of these green rooms may be in California, but what's worse is all of these green rooms may all be in different states, which means every one of these folks has to coexist, and as cannabis tourism picks up, they have to suffer through any manner of confusion that might happen from state to state. And when we get federal legalization, either a permission to register trademarks at the federal level or outright legalization of cannabis, these folks are all going to have a really big problem if they want to expand their operations. And keeping in mind, by the way, that dispensaries already are developing state-to-state growth strategies. Harborside, for example, is in more than one state. So the approach is piecemeal to registration and to searching. By the way, you always want to be looking at, to the extent you can, at Secretary of State's offices. In fact, Core Search has a really great platform that searches all the state Secretary of State offices for trademark registrations or applications, and sort of pulling together the trademark registration and the clearance piece. This is kind of an overview of what are we doing? Well, we're searching everywhere. We are applying both at the state and the federal level. And then, like that earlier slide actually demonstrated, there's a lot of common law rights that are being developed and relied on, but those are unfortunately limited by geography, which means ultimately you have a lot of coexistence in this industry. And oftentimes you're just advising your clients how to avoid potential confusion by consumers in the industry. Can I protect a strain name, Amanda?
Yeah, no, I'm just kidding. By the way, there were some questions in the Q&A. Yeah, totally, do it. There were some questions in the Q&A. I tried to answer them, but if you if your questions aren't getting answered by our later stuff, feel free to post again. Yeah, this is a question we get all the time. Our clients really want to protect their strain names. It's often a strain that they created or believe they created or own in some way, and whether they came up with those genetics or not, they tend to have come up with the name, and so they really want to protect it. Under traditional trademark law, unfortunately, they cannot protect strain names any more than you can protect any varietal. The easy analogy is wine. You can protect Sutter Home, but not Cabernet. You can protect the name of your farm, but not the name of the strain you're selling. That's the straightforward answer. It's the first answer that we give to our clients. It's certainly the answer if we were talking about protecting a strain at the federal trademark office. Not something you can do right now for the reasons we discussed before, but that would be the problem you run into. And we've actually gotten descriptiveness refusals for things like a Class 41 application that's providing information about cannabis. And if the mark is also a strain, no matter how rare, the trademark office will say, are you providing information about that strain? Because if so, this is descriptive. We seem to have avoided the, if not, it's misdescriptive, luckily. So we'll see on that. But so the short answer is no, you can't protect it. The longer answer is, number one, some states don't realize this. So you may be able to protect your client's strain name at a state level with a state trademark registration. But number two is that there are creative ways to use contract law to enforce in ways that you may not be able to with traditional trademark law. So whether that's authorized reseller agreements, certification programs, there can be ways for clients to try to control use of strain names, even if they can't properly protect them as trademarks. And where you go.
Real quick.
Yeah.
While you're pausing, while you're thinking, our CLE code for this session is EM38A. That is elephant, monkey, 38. That's 38. A, antelope. All right. Elephant, monkey, 38, antelope. All right. Carry on, please.
Thank you, Bree. We only have a few more minutes, and I know a few of you have asked questions about office actions, so I really want to make sure that we get to this. So we have some example office actions here that you might see. The goods identification, you'll get a refusal. We talked about this earlier with unlawful use. And they'll say, for example, here are the items that the proposed mark are applied to are unlawful. And then they cite the ones, in this case, the entire description, that may be unlawful. In this case, here, I'm just going to jump ahead actually to 25. In this case, generally using limiting language in a marijuana-related refusal, so a refusal citing the Controlled Substances Act, should do the trick if it is meaningfully possible to limit it. So for example, I might have a client who distributes cannabis, but they also distribute merchandise like tchotchkes for someone. And so I file for distribution services broadly. The goods and services are, distributing the goods of others. The trademark office sees that they use it with cannabis. They may ask, hey, do these services violate federal law? I'll be able to say no, but then I'll limit the services to say, none of the foregoing, including the distribution of marijuana, or, none of the foregoing, including products that contain more than 0.3% THC on a dry weight basis, trying to carve out whatever we can. We tried for a little while, and we still try, and I encourage you to try as well, to use less specific limiting language that isn't tied to the current standard on the theory that the law may change. There is one examiner who has been accepting them occasionally. He'll accept things that say like all of the foregoing in compliance with federal and state law, or in compliance with federal law. You don't even really need state, it shouldn't be relevant. And so that would be ideal. We are generally finding that the examiners are requiring a more specific carve out that says, it is not marijuana as defined, blah, blah, blah. But that's an option. If your refusal is citing to the FDCA, which you're going to see more of if you get inquiries like this, then your limiting language is going to be a little bit different, and you may need to amend your filing date as well. So the limiting language with a CBD refusal is usually something like none of the foregoing containing, all of the foregoing containing less than 0.3% THC on a dry weight basis, etc. If you filed for ingestibles, there is no limiting language that's going to save you unless you filed broadly enough that you can exclude CBD products entirely. But that's the importance of filing broadly and not including those unlawful goods. Mm-hmm.
We have been doing a little bit of, so exactly this, you can move the filing date with some intent to use applications. Sometimes you can kind of push back and really limit your goods identification and maybe get into allowance. But basically the examining attorneys are going to sit there and be like, you just wait till you submit that specimen. And if I so much as see CBD or even hemp on the label, you might get refused registration. It's still pretty murky about what's going on with if you just say hemp. You could try and modify to your foods only including grass ingredients, but like your client's probably actually not doing that. So the strategy really is, the question really is, what are you trying to do with these trademark applications for either CBD infused food or just like marijuana type stuff? And for marijuana goods, you're ultimately just going to get refused registration unless you really heavily modify your goods or services identification. But what we often tell clients is that the best case scenario right now is that your allowed trademark application or your pending trademark application is acting as a signifier to the world, or at least the United States, and then other people, I suppose, in other countries who might do global searches, that this is the mark that I intend to use in this industry as a whole and generally with these goods. And so, hey, attorney who's seen me on a search, go do some common law searching as well and look around. But the office actions are getting really complicated. So in response to that, the hemp question, so smokable hemp and like hemp e-cigarettes and stuff like that, you can get those registered. We actually just submitted a response to an examining attorney today on limiting some class 34 goods that included both smokers articles and smokable e-liquids to just exclude, or does not include anything with 0.3% or more, or whatever whatever it is. I literally use every single day. And so, but you have these, if you had started from the outset with anything indicating that it was like a hemp application, you're going to get these crazy 20 question office actions now that are basically asking if the hemp is legal, but in 8 different ways. The same exact thing. They're asking if the hemp was legal. Yes, the hemp is freaking legal. I told you that the first time. And they still don't even know exactly like what the documentation is that they're looking for. It isn't really standard. So, but I mean, honestly, I think a big part of the work right now, particularly in the hemp applications, is just working with examining attorneys, educating them, educating yourself. You might not even always know exactly how your client is procuring its legal hemp, or if your client's a cultivator, exactly what they're doing. So it's a good opportunity to really get to understand the industry and what your client is doing, and then share that information with examining attorneys. And in some cases, the examining attorneys are going to know more than you because they've talked to 25 other lawyers. And so, we're picking their brain sometimes, the more experienced one, and sometimes we're sharing information. So it's really an opportunity to expand your practice and your knowledge base. Sorry, was there?
I think I think we should, I think this is the topic we should wrap up and not talk about cases, but I think there's a practice tip here, which is that, they do ask you a lot of questions. And so we will respond to the questions in the office action response, but then there is typically a question, do the goods comply with the Controlled Substances Act, with the Food, Drug, and Cosmetic Act, et cetera. And we prefer to have the client make that declaration. We inform them what they're declaring, what the issues are, and then if they feel comfortable declaring that it's lawful, which they do because we've limited the language, then we have them sign it and we just attach that to the office action response. So, different attorneys have different preferences. We have our applications signed by our clients too. So it sort of mirrors that, but something to keep in mind if you're submitting a declaration or some kind of statement of compliance with the law.
Yeah. So we've only got 2 minutes left. I like that.
Yeah, we won't get into it, but trust us. Yeah. Well, go. See what you can do in 2 minutes.
Yeah. So should we do? I mean, I can really quickly. So we just have some cases out there. Basically, a mainstream brand against cannabis brand against hemp brand. The short of it is that either the courts don't know what they're doing, or they're doing things that aren't serving us well at all. And that is to say that the common law rights, or even the lawful state-based rights that your client might be developing for the moment, at least in the district courts in California, and we're waiting to see what Colorado will say, those rights will not be recognized when you're talking about like a federal dispute. So it's unfortunate, but what the Kiva case has told us right now, we're waiting to hear back on this Veritas case, is that exactly that these state rights are not going to either defend against or function in an enforcement capacity when you're talking about a federal dispute and federal rights.
Yes. So, our strategy is the same. Keep filing applications, keep putting the public on notice that your client claims rights in these marks, but stay nimble and be ready to change it up. I mean, we have times where by the time an application is examined, the filing strategy would have changed completely. And now we're stuck with whatever made sense 9 months, 2 years ago, because the delay can be so long. And so, it's fun working in this space. You get to be creative and a problem solver all the time.
Yeah.
And feel free to reach out to us.
Yeah, and I would read, and I should maybe throw in the chat that this most recent case out of the TTAB actually highlights or outlines some of the arguments. My to-do list is in the top corner. Some of the arguments that practitioners are making and are looking for to kind of push back on the unlawful use standard. So in terms of like what's going on in advocacy, we can do some advocacy at congressional level, either amending the Lanham Act or the MORE Act. Obviously, right now is going to deschedule or would deschedule cannabis. That's one way to do it. Another way is folks pushing back at the Trademark Trial and Appeal Board or even in district court against the unlawful use standard. And there's some really great literature, both that's already come out and about to be coming out on this topic. And then that's really it. That's like the two things we're doing, either getting some congressional efforts done or trying to push some stuff through the courts, but really it's an attack at this unlawful use. New states are legalizing. In California, something really exciting. We have our draft regulations for the development of appellations. So we're going to start protecting our California cultivators in the way wine cultivators, grape cultivators are protected. We're waiting for FDA. That's right. We have some draft guidance that FDA has already sent over to the president's office, but for some reason, I feel like I heard something recently that we don't expect that to.
It's just enforcement stuff. It's going to be the same as what we usually see. I don't think it's going to be game changing. Yeah.
And then global market, if you're attending these sessions, that there is a pretty big global market. There's a lot of CBD and hemp moving around. It's a big deal. Yeah, there's a lot going on. The new DEA interim final rule has come out. Public comment was just due on both the USDA interim rules and the DEA, so keep an eye on that, and that's going to affect all your hemp applications and what's going on in the world with your hemp clients.
All right. Great. Well, real quick, thank you so much. Yeah.
I'm going to butt in real quick. Again, CLE codes. The CLE code for this course is EM38A. Energy Maniac 38 alphabet. Again, thank you so very much. We do have some questions. I know you answered many of them, but I do want people to get a chance to get their questions answered. But I will back off and let you finish. Thank you so much.
Sure. Thank you, Bree. Where are the questions?
I think we answered them all within the chat.
Yeah, if they're in the chat, we answered them. Okay. All right, great. Yeah. I mean, if anyone else has questions, feel free. Oh, I see something in the chat. It says, thank you both so much. Thank you so much. Thank you. Here, let me put up this last slide. This is our bat cat we like to close out with. Here are our email addresses. Please feel free to reach out to us. We're always happy to chat about these issues. Generally, it's the kind of thing we do not just for work, but for fun. And it's just constantly in flux. So, if you want to chat out the most recent, okay, they can't see the chat on Big Marker. All right. Not sure what to tell you about that, but anyway, reach out to us. Our website is brandonbranch.com if you want to see more about us. And we would love to. We have a question. Any idea if an administration change will be friendlier or worse? Can't be worse. Guess it depends. If you're just talking about this, probably friendlier. Probably like we'll fill more positions and we can have more interagency communication. I don't know. We'll see. Yeah. All right. Well, I think I don't want to go over our time. I think we're supposed to end here. But if there are other questions, let us know. And yeah, feel free to reach out. We're around.
Thanks so much.
Thank you.